of jurisdiction, and within that law there will be an ancillary provision relating to practice and procedure, and that's the only way to harmonize the two. So I have two questions. One, that when we talk about under the Constitution, to such extent as is expressly authorized by or under the Constitution. So by to the Constitution mein aa gaya. So what does under the Constitution mean? Number one, and number two, the jurisdiction vested in the Supreme Court, like under the Competition Act, as I asked earlier, Section 44 says there's an appeal. So now that's not expressly given in the Constitution. So फिर उस law का क्या होगा?
My lord, I will answer both. I will explain, address each of the appeals under the statutory jurisdiction. But if I can just add one caveat to this,
आपका argument तो उसका ये है ना कि Competition Commission की entry है, उस entry में law बन गया है, और उस law में फिर ancillary power दे दी गई Supreme Court को.
Actually मेरा argument तो लाहौर High Court में बिल्कुल फर्क था. My ladyship, Justice Ayesha Malik did not accept that. So I will go by the law declared by my ladyship.
Which is under challenge before us now.
It is under challenge before.
Then don't talk about cases which are under challenge. मुनासिब नहीं होगा.
जी ठीक है. मैं इसीलिए मैंने वो obviously अपने written submissions भी किया.
इसी के आपको I just want to put a question है, पर आप उसका इकट्ठे जवाब दे दें. Entry 58 भी थोड़ा सा shed some light as to matters which under the Constitution are within the competence of the Parliament. So could not law mentioned in 191 pass the test of 58, number one? And what does it mean to relate to the Federation?
Yes. I will address. If I can just add one point. In this formulation that I have sort of submitted before the court, that 191 leads you to 142 and then entry 55 and then 59. There's one overarching principle that will be in play, that even if a law passes through all these hoops and makes a provision for practice and procedure of the Supreme Court, it still cannot do so in a manner which undermines some constitutional principle, like independence of judiciary. Now,
well, that's a separate question. We are still on the competence issue. Once we have that law, then that has to be tested on the grounds of. Yes. But let's continue the competence issue first.
Yes. So the first point. So I have given Your Lordship two examples of of instances which could be used as to say that the Constitution expressly authorized. Enlargement of jurisdiction is expressly authorized by the Constitution. One was 247(7), my lord. Then Article 185. The third one was something that was pointed out by my lord Justice Munib Akhtar in his Jamal Medical College judgment. Article 212, 2 and 3. That's where a provincial law setting up a service tribunal is then. There is an act of Parliament saying that with respect to appeals for that from that tribunal, the jurisdiction would be with the Supreme Court under 212(3), and Your Lordship specifically said that's an instance of enlargement of jurisdiction. So these are three examples that I could think of where express authorization by the Constitution dealing with the jurisdiction of the Supreme Court per se exists. Now, my lord, what do you mean by under the Constitution? So, as a starting point, Your Lordships will note what my Lord Justice Munib observed and I submitted, that entry 55 originated in its present incarnation in the interim Constitution of 1972. And the interim Constitution of 1972 had a catch-all provision, Article 188, which said that the Supreme Court will have such other jurisdiction as may be conferred by law. So that Article 188 has been omitted and we are now left with entry 55. So we have to give some meaning to these words under the Constitution. Well, it is, I would say it's not really clear, but I have a point of view on which I'll place before the Honorable Court. I say, my lord, there are provisions in the Constitution which allow for a particular framework to be created on a particular subject on which a hierarchy of fora could be created, and then against that an appeal to the Supreme Court could be provided. Well, there are two specific examples that come to mind. One is Article 6, Clause 3, This deals with high treason. My lord, high treason, much as it defines what high treason is. And then it says, Majlis Shura, Parliament shall by law provide for the punishment of persons found guilty of high treason. Now, in pursuance of this, my lord, the 1976 Act, which is the 76. Well, this was the Criminal Law Amendment Special Court Act of 1976. This was promulgated, and Section 12, subsection 3, provided it allowed for the setting up of a special court to comprise of judges of the High Court, and Section 12, subsection 3 said.
What's this Act? 76 kya?
Well, this is the Criminal Law Amendment within brackets Special Court Act 1976.
ये इसकी date of promulgation क्या है?
ये है जी, it was published in the Gazette, my lord, on 19th April 1976.
26.
76.
इसमें amendment नहीं आ चुकी हुई?
My lord,
Check कर रहे हैं।
I can check, but not according to my knowledge. I'll double check.
You wanted to read section 12.3.
12.3, any party aggrieved by the final judgment of the special court may prefer an appeal to the Supreme Court within 30 days of the passing of the judgment. So this provides a direct appeal from a special tribunal. Now this special tribunal was set up on the touchstone of Article 6. This is not...
This power vests in the Constitution.
My lord, my submission is...
Read it and tell me does, which provision?
Article 6, 3.
Partly, where does it say?
It says Parliament shall by law provide for the punishment of persons found guilty of high treason.
It only deals with the matter of punishment. Where does it create the power to appeal?
My lord, but it has to be there because punishment could only be through a court. It can't be otherwise.
भाई appellate forum तो 12.3 create कर रहा है ना?
Punishment के लिए law
भाई आप बात समझने की कोशिश करें ना?
My lord.
आपने इसका तस्करा किया आर्टिकल 6 का। आर्टिकल 6 के तहत हाई ट्रीजन एक जुर्म होता है, ठीक है, जो आइन को पामाल करे, ठीक है, उसके तहत सजा दी जा सकती है। आइन सिर्फ ये इख्तियार दे रहा है अब पार्लियामेंट को क्या इसकी सजा कितनी होना चाहिए, 10 साल, 15 साल, डेथ सेंटेंस, लाइफ, ये तीन में कोई और अल्फाज ऐसे नहीं हैं जिससे हम ये समझ पाएं कि इसमें अपील का भी हक दे दिया गया है। तो अगर यहाँ नहीं दिया गया, या तो आप फिर कहिए जो अपील का हक दिया गया है सेक्शन 12(3) के तहत वो गैर आइनी है, तो फिर तो बात आपकी समझ जाएगी। अगर आप इसके बरक्स आर्ग्यू कर रहे हैं तो ज़रा अपनी बात वजाहत से करें कि मैं समझ तो जाऊँ कि आप कहना चाह रहे हैं।
My lord, my submission is that
just adding to that question, under आप कह रहे हैं under की मिसाल आपने 6.3 दी. Now, as I am reading 55 is that there has to be an extent expressly given in the constitution कि आप enhance कर लें jurisdiction या फिर law में भी होगी है. इसका मतलब there is a law which talks about enhancement of jurisdiction of the Supreme Court. So फिर law तो एक है ना, there is a law that must be with, how is that law, how does that law come about?
that law, the authority, the competence to frame that law comes from the body of the constitution, not Article 6.
नहीं ये तो इसकी हद तक है
मैं ये कह रहा हूँ
इसमें भी नहीं है, इसमें भी इस तरह एक्सप्रेस नहीं है कि you can confer jurisdiction of the Supreme Court as a substantive right of appeal.
My lord,
so it's tricky. I
my
mean,
lord, all I'm saying is that this is a point which
so you must admit in this,
is not,
this unclear, this under the constitution.
This is res integra, this is still have to be interpreted by my lord.
Bandari Sahab, we appreciate your fairness. I mean, it's good. I mean, that is appreciated.
I'm just placing this. Kindly also turn to Article 225.
There is a specific power conferred by the Constitution to frame a law. Then that law can be framed, and in that law, by definition, an appeal can be provided. The Constitution may not specifically say such law may provide for an appeal.
Well, it's inherent in it.
It is inherent in it where the Constitution confers the power to frame a law on that particular subject. It gives you all other ancillary powers which include the power to provide an appeal.
Absolutely.
But in terms of 91, in the first place, there is no power.
There is no
Power
power.
to frame rules is only conferred on the Supreme Court. And item 55, even if it is used standalone, does not meet the muster.
It doesn't.
If you say this, then you are attaching redundancy to the words subject to the Constitution and the law is redundant.
No, my lord.
Then what does it mean?
I'm not saying that.
Then what does it
For
mean
example, if your lordships, for a moment, let's assume that the
then? Let's not assume. Give me
no,
this
I'm
case.
giving, my lord, I'm giving an example. I'm giving an example. For a moment, assume that the provision that I just read out, section 12, subsection 7, which allowed for an appeal.
प्रैक्टिस एंड प्रोसीजर एक्ट पर सुप्रीम कोर्ट में समाअत जारी। चीफ जस्टिस काजी फायज ईसा की सरबराही में 15 रुकनी फुल कोर्ट समाअत कर रहा है। वकीला के दलाल जारी, कोशिश है कि केस को सुनकर आज ही फैसला दें चीफ जस्टिस।
स्टॉक मार्केट में तेजी का रुझान, 100 इंडेक्स में 100 से ज्यादा पॉइंट्स का इजाफा, डॉलर के मुकाबले में रुपए की कदर में इजाफा। डॉलर मजीद 1 रुपए 5 पैसे सस्ता, इंटरबैंक में डॉलर 285 रुपए और 65 पैसे पर आ गया।
वाइस एडमिरल नवीद अशरफ पाक बहरिया के नए सरबराह मुकर्रर। तब्दीली कमांड की तकरीब 7 अक्टूबर को इस्लामाबाद में मुनाकिद होगी। वाइस एडमिरल नवीद अशरफ इस वक्त नेवल हेडक्वार्टर्स में चीफ ऑफ स्टाफ के फराइज सर अंजाम दे रहे हैं। तर्जुमान पाक बहरिया।
मुल्क में आम इंतखाबात की तैयारियां, सियासी जमातों की जानिब से इंतखाबी सरगर्मियां भी भरपूर अंदाज में जारी। चीफ इलेक्शन कमीशन की सरबराही में अहम इजलास, आइंदा आम इंतखाबात की तैयारियों के हवाले से गौर।
हल्का बंदियों का ऐलान हो चुका है। इलेक्शन के लिए 25 या 28 जनवरी की तारीख आ सकती है। क्लियर हो चुका है कि नवाज शरीफ वतन वापस आ रहे हैं। कायद नून लीग एक बार फिर मुल्क और कौम को खुशहाली की जानिब लेकर जाएंगे। लीगी कारकुन अपने कायद का भरपूर इस्तकबाल करेंगे। रहनुमा मुस्लिम लीग नून ख्वाजा मोहम्मद आसिफ और सायरा अफजल तारड़ की सियालकोट में मीडिया से गुफ्तगू।
पाकिस्तान